just to sort of kick us off, we've got a few slides where I'll talk you through the priorities for our guidance. Now, we've picked these, we've looked at the different impacts that things are going to have that we anticipate that have come in from the bill. We've worked together with colleagues from DSIT to try and work out what kind of pieces of guidance we think people are going to need most and what's most urgent. We've also talked to our stakeholders about what they want to see, and then we've also looked at some of the knock-on effects that some of these pieces of guidance are going to have on other pieces of guidance that we've got to do and try and put this big jigsaw puzzle together. So the first one that we've identified is our international transfers guidance, and obviously we think this is really important in terms of our obligations around economic growth. I also wanted to say how much I enjoyed the session this morning about explaining complex legal concepts in a way that makes things easier for people. And we are well aware that our international transfers guidance is one of our trickiest areas. So we're going to be working really hard, as well as including the new provisions from the Act into our international transfers guidance, to try and make it a bit more user-friendly. So my team work very carefully with our legal team, and we've invented a new word, so we're going to guidancify it for you. So look forward to that. Then we've already had mentioned automated decision-making. So this is an area where we think we need to prioritise this and get this going as quickly as possible so that people can make the most of the new provisions that are there in the Act. Purpose limitation. This is kind of a sneaky one that impacts on various other pieces of guidance. So we've got the new recognised legitimate interest provisions, which are really closely linked to purpose limitation, and also the work that we are doing on research provisions. So it's a member of my team who's on this topic, and we're busy working out how that's going to impact on all the other pieces of guidance and looking at the interplay there. We also, as Robin mentioned, we've got some provisions on higher protections for children. So we have a team of specialists who've done a lot of work on our age-appropriate design code, who are putting together some new guidance there to help people to comply. Robin's mentioned the right to complain as well, so we're putting together guidance on that, because obviously once that obligation comes in for businesses, we want to be able to help those businesses to do that and to get it right. So we're having a consultation on that one very soon. I'll talk you through some of our upcoming consultations when we get to a later slide. This is another one we're going to have to reverse engineer some of our other pieces of guidance to make sure that when people are looking at those, they actually know that they do have the right to complain and how to exercise that as well. So we'll be looking at inserting that information into some other pieces of guidance where it's not previously there, so that people can exercise that right. Lovely. I've already mentioned recognised legitimate interests. This is another one that we will be consulting on very soon, so I'll come back to that. And then, as we've said, we've got changes to PECA and also to breach reporting as well. So that's another area where we're trying to get things up and running so that people understand what's required. Next, we've got scientific research. Again, as Elizabeth and Robin mentioned, that's one where there is a lot of interest and a bit of change. It's probably one of the ones that we've actually had the most inquiries about while we've been out at speaking events and talking to people. We've got a consultation coming up on that as well, so I'd really encourage people to get involved in that. And then we've obviously got cookies and storage and access, so we'll be, again, putting our guidance forward very soon on that to try and clarify that and help people. Lovely. So we're going to have changes that come into force to help people with new codes for PECA and Part 3. So I've been working very closely with our Codes of Conduct team to start scheduling that work. And then again, our law enforcement guidance, we're actually keen to make some updates to that in general to make it a bit more accessible and user-friendly. And so we thought we would take the opportunity of these new updates that are required by the Act to actually have a bit of a tidy up of our law enforcement guidance as well. So you can see there from the slide, we've got specific changes that we're making to logging requirements, national security exemption, Part 3 SARS, and Part 3 international transfers as well. So those are the things you can expect to see popping up first, but we do actually have a plan to improve our whole suite of law enforcement guidance, so do look out for that as well. And then we have our work on Part 4 designation notices, which are a new requirement for the bill. So we thought, as I mentioned, that we're going to take this opportunity to get some other stuff out there. So we have been working to make some changes to our SAR guidance. Our SAR guidance is probably the most popular thing on the website. And we've been doing some general updates, some tidying up, some clarifications, as well as the due changes. But we've also been should-coulding our guidance. Now, I don't know how many people have come across this on the ICO website. It's something we've started fairly recently, so we are taking the opportunity while we're doing some of our updates to put our new must-could-should methodology and apply that to some of our existing guidance. So this is part of our drive to improve regulatory certainty. So what we want is to make it really clear what is an absolute cast iron legal obligation right through the scale to what is good practice. So you can expect to see more of that coming to our pieces of guidance. Now, people who were chatting to me at dinner last night might have noticed that I'm a massive Lord of the Rings nerd. So I always say that we have as much guidance on our website as all 3 volumes of The Lord of the Rings combined with The Hobbit and The Silmarillion. So this is a massive, massive undertaking for us to update all of our guidance. So please do bear with us. As I said, we've tried to prioritise to make sure that things are as user-friendly as possible, and we've tried to make sure that we're doing the things that people really need first, but it is going to take us quite a long time to update our master works of literature. So we're doing a risk-based approach to this. So we are splitting our updates into 3 phases. So all of the things that I have described to you on the previous slides are what we're calling our phase 1 products. So they are all the priority pieces that we have identified that we need to get done first. We then have our phase 2 stuff. So to try and give you an example, if we are making changes to our purpose limitation guidance in phase 1, that will be to our core guidance on purpose limitation in our guide to GDPR. But what we also have is all sorts of other guidance products that actually have a description of purpose limitation within them, explain purpose limitation in particular contexts. So once we've updated our main core guidance on purpose limitation, as part of our phase 2, we're going to be looking for all of those other products that have references to purpose limitation, and we're going to be changing those so that everything matches and everything is consistent. Then we have our phase 3 stuff, which is where we're going to be updating our statutory codes, and we'll also be looking at some new statutory codes. I'll talk about that a little bit more in a minute. And we'll also be updating everything else. So basically everything that isn't in phase 1 or phase 2 is going to get mopped up in phase 3. So we're busy with this huge exercise at the moment to risk rate all of our products and prioritise those. So that's kind of the way we're doing it there. Please. Okay. Yep. So I mentioned we've got our updates to existing codes. So we've got our journalism code, we've got our data sharing code, and we've got our children's code. In order to make changes to those changes actually have to be laid before Parliament. So it is a slightly more complicated process than it is to update our other guidance products. So we'll be doing those to reflect the changes in the Act, but that is going to take us a little bit longer and be slightly more complex to do. And then you're probably aware that the government has committed to laying regulations for new codes. These are really big undertakings for us. We want to make sure that we get things right. We want to make sure that we involve all the right people, all the right stakeholders, do our consultations. So we will be working on those, and there'll be much more information coming on that in the website as regulations and things are laid, but they are on our radar. Get the next one. Lovely. So our short-term plans, so these are for over the summer. In fact, so short-term that in the gap between me sending the slides for the conference and me rocking up here, our international transfers guidance consultation has actually gone live. So if you are interested in contributing to that, that is available on the ICO's website. So please do go up there and have a look and get involved, because we want to make sure we get this right. So the more input we get from everybody, the better job we can do. So please do get involved in that. And then we've got quite a few things coming over the summer. So we're going to be having our consultation on recognised legitimate interests. That is going to go live soon. The reason I'm being slightly vague and saying soon is because what we are trying to do is, as much as we possibly can, stagger our consultations so that everything's not starting at once and everybody's not trying to respond to everything at once. So we are looking quite carefully at our sequencing. We've got the consultation on the complaints process coming up as well, and there'll be new resources about that on our website. And then we're going to be slightly later, so we're looking at September for our research and statistical purposes consultation. And again, I'm sure lots of people in the room will be interested in that. And then we also have our upcoming guidance that I trailed on subject access requests, which again should be published in the early autumn. We're just doing some of our final legal checks and quality controls and things on that. So that is nearly ready to go. Lovely. So we've also done a few things to try and help people and to make it a bit more obvious what has been updated and what hasn't. Couldn't think of a better name for these, so we're calling them health warnings. So what you might notice if you go and look at any of our guidance at the moment on the website is that there's a little banner across the top that says that data protection law has changed, and it's explaining to people what has changed. It's giving them access to resources that help explain the changes, and it's also warning people that this particular piece of guidance that they are looking at has not yet been updated to reflect the changes. So as we make the changes to each guidance products, those health warnings will actually start to disappear, or they might start to get modified if you've got a piece of guidance that has provisions that are coming in at different times. So if you are using the guidance on our website, please do just take note of the health warning at the top and just make sure that you know the status of the piece of guidance that you're using. To try and help people even further, we introduced this process of change notes. Again, it's relatively new to the ICO website. It's not something we've done for the Act, but it's something I just thought it was worth flagging to you. So we noticed that a lot of other regulators and providers actually put these change notes on their pieces of guidance, so when they do change it, people can see what's changed, why it's changed, and when it's changed, which also helps people understand what's different, but also when it was different. So as Sam was saying about using our regulatory powers and thinking about what was in place at the time, you can actually look and trace the guidance back and see what was in place at the time when something occurred. So those are appearing on each piece of guidance, and as we make the due changes, you'll see more and more change notes finding their way onto the website. And then, as Sam has also mentioned, we've put a document up on the website about our regulatory posture. We will, as Sam said, be regulating based on what the law was at the time that whatever incident occurred that we are looking into, but we will also be considering what our guidance said at the time and what was available. So we will be using our regulatory discretion and taking a very sensible approach to how we deal with those things.